Hello, I'm attorney Dan Marr from the Nashua law firm of Hamblett Kerrigan here in New Hampshire. I've been practicing the law for about 36 years, 37 years in New Hampshire and about 28 years or so in the Commonwealth of Massachusetts. I'm going to be talking today about evictions in New Hampshire. I represent landlords, both commercial and residential, and in regards to that, one of the things you want to do sometimes with a tenant is you want to remove them from the property, and the real goal of the eviction process should be not to try to also collect rent. That might be another revenue or avenue for you, but you really want to get that person out at that time. Or you might be even using that eviction for leverage to get payments. But the system works in such a way that you have an opportunity after you do your eviction notices. You have to do what's called an eviction notice. It used to be called notice to quit, but it's eviction notice. And if there's a rent owed, there's a demand for rent that you have to do. There's several requirements. Sometimes there's 7 or 30-day requirements. You have to follow those. I'm going to be concentrating on dealing with the case itself. Once you get through that eviction notice process, you do a landlord tenant writ. There's on the first sheet of that landlord tenant writ, there's a box where it might make sense that you can collect $1,500 quickly by checking the box, so that you can only collect $1,500, $1,500 of the amount owed. But maybe you're thinking, well, geez, I'm going to be in the eviction in the court anyway. I can get that quickly. Don't do it in most circumstances. Do not check the box, because under New Hampshire law, there's a district court rule, so Circuit Court District Division 5.5, which is less clear than the Supreme Court, but the New Hampshire Supreme Court has made clear in the case of Maddie versus Shippey Auto, the 2005 case, that if you don't check the box, the district court rule does say, and the Supreme Court has confirmed for the district court judges, the person doesn't get to deal with a counterclaim. They don't go and say, well, look, the landlord was supposed to be doing these other things, and therefore I should be able to get damages and offset that against rent. There are certain things as to habitability of the property and other specific provisions in the landlord-tenant statute upon which the tenant can make a defense. They can escrow the funds, and there's a way to provide a defense. But I'm talking about there's tenants, what both commercial and residential, will come up with some interesting counterclaims. They may say you're breaching the lease because maybe the situation is they're saying that you are allowing, in a commercial situation, you're allowing a competitor to be in there when the lease says you're not supposed to. Or you're in a situation where I had a case where somebody was saying that the landlord should have been trying to find alternative housing for this person. Those types of claims aren't defined in the landlord-tenant statute, and that counterclaim, because I didn't check the box, couldn't be made. Very frustrating for the tenants, both residential and commercial, when they come in and they have this long-winded or very expansive counterclaim that they are saying they want to present in this quick eviction hearing. And the court can say, what they do say is, Attorney Marr didn't check the box, or your landlord didn't check the box, and therefore you don't get to make that counterclaim. It's a huge benefit for you, because you really want to get, at that stage when you're at that eviction hearing, you want the person out, and you don't want them to be able to raise these defenses as to what you did wrong or what you should have been doing for them, and therefore a counterclaim. It's a summary process, and if you don't check that box for that $1,500 worth of rent, and that's not worth it for you, then you don't have that obligation to listen to their counterclaim. You can really shut them down right away, and the court should not hear it. I do see some circuit court judges, newer ones, that are the district court rule 5.5 is could be clear, but the Maddie versus Shippey Auto, it's a 2005 case decided May 20, 2005, is quite clear. And if you Google it, bring a copy of it with you too, or copies for the other side too, to your hearing, and present it to the judge if he or she doesn't already know about it, and you should be able to get through the eviction without a counterclaim very well. Again, I'm attorney Dan Marr. I do represent landlords in such situations, and I'm happy to help if the opportunity, or unfortunately the unfortunate opportunity, arises for you. I'm here at 603-883-5501, 603-883-5501 here in Nashua. You can check out our website of NashuaLaw.com. I do weekly vlogs, and you can look at this vlog or other vlogs that I've done on a variety of legal topics. And again, I'm ready to help you if there's no conflict if the opportunity arises. Thank you.